Hi, I'm Jamal Jones, the founder and principal attorney at Jones Health Law, and today we're going to discuss whether doctors and nurses have to self-report to the Florida Department of Health if arrested. In our society, medical professionals have always been held to a higher than average standard. Doctors and nurses must abide by several professional rules of conduct that not many other professionals have to keep in mind. This in turn also means that your personal life is up for scrutiny as well. Ethical standards and moral values are usually private assumptions, but for those who have chosen the medical field, those normally private matters can have a deep effect on your employment status. Any serious off-duty conduct issue must be reported, reviewed, and taken care of on a case-by-case basis. So what are the Florida requirements for self-reporting? In Florida, doctors are required to report all criminal activities committed after they receive their medical license, even though it is not in relation to employment and occurs after regular working hours. Any report or complaint filed towards a medical professional will be investigated by the Florida Department of Health. Being placed under arrest can trigger disciplinary action from the state licensing boards. Medical disciplinary actions require a much lower burden of proof than federal cases. It is possible to be penalized, face Medicare, Medicaid exclusion, and potentially have your license revoked based on the severity of the crime and investigation. It is entirely possible that a physician can face the loss of their medical license even if an investigation does not result in criminal prosecution and a conviction at a trial. What about complaints against medical professionals? Well, the most common criminal concerns leading to the harshest disciplinary actions towards a medical professional include healthcare fraud, solicitation, moral turpitude, dishonesty, or deceit in any jurisdiction in the state. According to the Florida Department of Health's website, they do not carry out complaints regarding the fees charged for individual procedures, missed or canceled appointments, unfair customer service, rudeness or disrespect, bedside manner, professionalism, or personality conflicts against medical professionals. Complaints against medical professionals can lead the Board of Medicine to issue citations based on the type of and severity of the complaint. It is completely free to file complaints against medical professionals. The only potential fees may be for requesting copies of medical records if deemed necessary. Complaints remain confidential until the panel determines reasonable cause and a violation is issued. So how to report? According to the Florida Board of Medicine, all criminal activities after receiving your medical license must be timely reported. The board provides various options for reporting, including email, online service, portal, or via regular mail. If a complaint is issued via sending an email or a letter, the correspondence must include the date of the offense, the activity that happened, and the county and state of jurisdiction. The complaint cannot reach processing without the proper information. The Florida Department of Health's Medical Quality Assurance, or MQA, launched a user-friendly online portal. The portal was developed in collaboration with the Agency for Healthcare Administration, otherwise known as AHCA, to allow for easy reporting of any complaints against medical providers, from fraud to unlicensed activity and violations. The portal offers education on the different federal agencies for complaints as well.